seconds to go. Start. In the written statement, it was alleged that the appellant company was owned and controlled by the family of Bajoria, headed by S.S. Bajoria, prior to May 1986. The said family was closely connected to the respondents. The appellant installed a paper manufacturing mill at Saharanpur in 1935-36 and offered dealership to the respondents for Delhi and Bombay markets. The dealership of Bombay was given up in or about 1955-56. The management of the appellant changed in May 1986. It was asserted by the respondents that the appellant has not rendered true and proper receipts and a sum of rupees 45 lakhs are due from the appellant. It was also alleged that the bills raised by the appellant are based on fictitious transactions which are tainted with fraud, deceit, and circumvention of law. Such transactions are therefore against public policy and void ab initio. The respondents further alleged that in 1972-73 the managing director of the appellant approached Shri Nagarmal Jaipuria and suggested that the respondents should receive certain bills drawn on them in as much as the appellant intended to sell certain quality of paper in open market at prices higher than the mill price. The goods could not be taken out from the mill unless accepted by one of the wholesalers or dealers. At the threat of termination of the wholesaler agreement, the respondents agreed for such proposal. The respondents averred as under. Near about the same time, the plaintiff, in addition to the selling of papers in cash in open market, also indulged in tax evasion of the sales tax on direct sale from Saharanpur was 4%. The sales tax, if the goods were transported to Delhi depot of the plaintiff and sold from the said depot, was nil. Thus, there was a net tax saving of the value of the goods sold in the open market at Delhi. There is no sales tax leviable on the sale of paper from the dealer to dealer at Delhi. If the sales were made directly from Saharanpur, the sales tax leviable was 4%. The dealer to dealer transaction of sale did not attract payment of any sales tax whatsoever at Delhi. The plaintiff, in addition to making profit by sale of paper in the open market at the price higher than the mill price, also wanted to pocket the sales tax which would have ordinarily been payable had the sales been made from their mills at Saharanpur. This whole ingenious scheme and device was tainted with fraud, and the Jaipuria, under undue influence and coercion, were made to submit to the illegal transactions which were indulged in by the Bajoria's plaintiff. One of the issues framed after completion of pleadings was whether the alleged bills forming the claim in the suits have been raised on the basis of the fictitious and fraudulent transactions. The suit has been dismissed by the division bench on such issue inter alia on the ground that documents had not been proved by summoning the person who had issued such large number of documents. The appellant filed an affidavit of Sri A.S. Bhargava, retainer, formerly General Manager, Management Services, on 8 December 2003. In such affidavit, the appellant has produced 976 documents, including copies of all the invoices, debit notes, delivery challan, ST1 form, interest debit notes, letter of the respondents, credit notes, and the statement of accounts. All the invoices are stamped and signed by the respondents. The appellant also produced ST1 form in respect of each of the invoices stamped and signed by respondents. In the cross examination, the witness stated that in case of sale transaction by the company manufacturer with any wholesaler, the sales tax can be avoided against ST1 form. However, if the manufacturer would sell these goods directly to any retailer or consumer, sales tax would be payable. He further deposed that he has not placed on record the copies of the books of accounts and that the bills cum challans have not been acknowledged by the respondents in their presence. He stated that the respondents used to lift the material from their go down stock.